Um, yeah, so it's okay to record your talk, right?
Yes, yes, yes.
Okay. All right. So the recording has started. As you can see that it is, I mean, noon Indian Standard Time. So very warm welcome to everyone. So this is so we are into the final day of sale, and we have had many intriguing talks by several artificial intelligence and law experts. So we have seen perspectives from the legal experts, how AI can help them. We have seen perspectives of the AI experts, uh, like how they can contribute for the betterment of artificial intelligence and law in general. So that belief forms the bedrock of our entire, I mean, basically symposium. So we are together working towards a brighter future for artificial intelligence and law. And it gives me immense pleasure to welcome Professor Angshuman Hazarika, uh, who is an assistant professor at IIM Ranchi, where he teaches business law and ethics. He's also a visiting faculty at IIIT Ranchi. He completed his doctoral degree from Saarland University, Germany, on the topic of state to state arbitration based on international investment agreements. His area of interest include investment screening, commercial and investment arbitration, and interaction between IT and law. So as the title of his talk indicates, that he is also favoring our quest for basically a better future for artificial intelligence and law, because it reads arbitration and artificial intelligence a match made in heaven. So we are very excited to listen to what you have to say. So the stage is all yours, Anshuman.
Thank you, Dr. Ghosh, and thanks to the organizers of SAIL for inviting me for this session. Also, thanks to all the participants and attendees for coming forward to join me in this discussion today. I'm very happy to present to all of you my thoughts on the topic. And of course, I would like to listen from all of you in case during the presentation also, if you have any queries, please feel free to stop me and ask me questions. We, of course, have the chat box as well. Just one small point from my end, the views are personal only. They do not represent any other party, norma organization. And any brand names that I mentioned, I do not claim any rights over them. So just for the purpose of the recording. And yes, so let's dive in. We'll start off with an introduction to the topic of arbitration and what it actually means, because we have heard a lot about it. Arbitration is in the spotlight these days in India. Uh, and uh, and of course, it is in the spotlight because of a few decisions which did not go in India's favor in investment issues. So that is the first thing that we have all seen in the newspapers. But let's try to dive into the topic. First, let's try to understand about arbitration, and then we go on to explain or understand the relationship between arbitration and artificial intelligence and where we can take it from here. Uh, it's a very exciting topic. It's something which is coming up and which has already started to influence the field of arbitration, that is artificial intelligence. And I think there will be much more happening. There will be much more happening in the near future. But let's begin and let's try to understand about the topic. So just in a few seconds you should see my shared screen. And yes, great. Great. So, for everyone, since there are people from different domains here, let me start off with an understanding of what exactly is arbitration and why is it a little different from dispute resolution in courts in general. So, when we say dispute resolution or when we talk about dispute resolution, our idea from movies particularly and our general social discussion is that dispute resolution normally takes place in courts, from those who are in India. You must also know that a dispute resolution also sometimes takes place in slightly different forums like panchayats, where There is, for local small disputes in villages, they have the panchayat. And of course, you sometimes have lok adalats, where people come together to resolve disputes in bulk, and these disputes are then resolved by local experts and local prominent citizens with a judge in supervision. But yes, the normal idea about dispute resolution is that this is something which happens in the courts and judges, and in many countries the jury also play an important role in the entire dispute resolution process. But arbitration is slightly different. So how is it slightly different? The issue here is that in case of arbitration, it's a private process where the disputing parties agree that one or two individuals will make a decision about the dispute after receiving and hearing arguments from both of them. So the basic issue here is that the parties say, okay, we will not go to the court, but what we will do is that we will appoint one or two persons who we call as arbitrators. Normally it is an odd number, it's either one, three, or five. So they appoint arbitrators, and then we give them the information about the dispute that we have, and we ask them to resolve the dispute. So it's parties coming together basically to agree that we will not go to the court, but what we will do is that we will resolve the dispute individually amongst ourselves through private individuals. So why do the parties generally select arbitration? Basically, they believe that the court process might take a long period of time, or that the judicial process, the judges who are dealing with the dispute may not have the requisite expertise to deal with the topic in particular, because it might be a very specialized issue. Now, before we delve further into the topic, let's look at some key features of arbitration. The first thing is that arbitration is generally voluntary. Now, when I say voluntary, this is when I use the word generally before voluntary, it means that sometimes it may also be imposed upon the parties that you should go to arbitration. Now, what are these situations when parties are forced to go into arbitration? So something that we have in India, particularly after recent amendments in the company laws and the Commercial Courts Act, is that parties are now required to go to arbitration for resolving certain commercial disputes mandatorily. So even if the parties did not have an agreement to go for arbitration, they will be forced by the courts to go for arbitration. Secondly, sometimes in family law issues, what happens is that the court says that we will not like to wash the dirty linen in public. Let's go to an arbitration or have a mandatory arbitration, and then come back to the court, and then you can resolve the dispute. Thirdly, sometimes what happens is that one party, what it tries to do is that it tries to avoid arbitration even though they may have an arbitration agreement themselves. So what they try to do is that they try to bypass this agreement for arbitration, and they instead go to the court and then tell the court says that no, you have an agreement for arbitration, why don't you go back and arbitrate? So yes, it's mostly voluntarily, but sometimes courts can also force you to go for arbitration. Second is that the second feature is here is that arbitration is private, which means that there is no public information generally about the dispute. Now, I say it's generally private because what parties can choose to do is that parties can, by for the sake of transparency, for the sake of public policy, what they can choose to do is that they can choose to put up the core case material that they have their submissions before the arbitrator, or the award by the arbitrator before the public, on a public forum, on a website, or any other forum which they choose. But if they choose, then generally it can be kept private also. There are exceptions to the rule, like we'll talk about investment arbitration, where it is now mandatory to make the information public. But yes, it can be kept private for most of the scenarios. The next thing is it's conducted by non-judicial authorities. So a prime feature of arbitration is that the arbitrator is not a judge. So he's not appointed by the government, neither does he get a permanent salary from the government. He's a private person, he's a non-judicial authority, and he is not a judge. So please do not confuse it with the fact that sometimes retired judges act as arbitrators, but they are now acting in the capacity as a private person. They're not acting in the judicial capacity. So arbitrator is not a judge. The fourth point here is that why this is also very important, that why we are discussing arbitration and artificial intelligence. It's that rules can be set by the parties, or they are very flexible. So what this means is that the parties can decide how they will go ahead with the dispute resolution process. So what this actually means is that the parties can be flexible about introducing new technology into the dispute resolution process. They can be flexible to introduce new ideas as to how they should go ahead with dispute resolution. So arbitration is quite flexible. Rules are determined by the parties. And the only exception to this is sometimes you decide to arbitrate through a center. So it's center. So just to give you an example of a center, so the Bombay Chamber of Commerce, they have an arbitration center there. So in case you decide to arbitrate through the Chamber of Commerce in Bombay, then you have to follow their rules. Or the international ICC, International Chamber of Commerce, they have an arbitration code there. So if you decide to go for an ICC arbitration, you have to follow their rules, but otherwise parties are flexible. Now, the non-involvement of a judicial officer or a judge means that the award or the decision given by the arbitrator cannot be enforced directly. So one more feature of arbitration is that you need to take support of the judicial system to enforce the award. So you may have an award from an arbitrator in hand, but you may not be able to enforce it unless the judiciary supports you in enforcing the award. So the judicial system is somehow related to arbitration at the enforcement stage. Of course, there are other roles as well. We'll talk about it, but it's related there. And arbitration also requires a supportive domestic law framework. Now, if a country does not recognize arbitration per se, or if a country does not provide for arbitration in its laws, then you cannot have arbitration in the country. So you need to have a domestic law framework. So it is indeed very rare that a country would not recognize arbitration in present days, but it's not something out of the world. So just to give you things in perspective, there are a few Central Asian countries where laws governing arbitration were only framed in the past decades. So they were not there for the last few decades, and laws governing arbitration have come up only recently. And lastly, arbitration can involve all sorts of parties. So they can involve countries, they can involve states within the countries, they can involve private parties, they can involve individual persons. So it can involve all sorts of parties. Now, before we move ahead, let's discuss one or two cases where arbitration is in the spotlight. So the primary case where arbitration is in the spotlight these days is a dispute between a country and an investor, or an investor state arbitration. So that is the case of Cairn India, where Cairn India objected that India had imposed retrospective taxes on it and wants to get back the money that it had paid. And then it brought about an arbitration proceeding against India, and India unfortunately lost the case. And so India now is trying to settle the case, or is trying to appeal against the award of the arbitrator. Similar factor happened in Vodafone, where again this is an issue of retrospective taxation, where Vodafone again took the Indian government to an arbitration tribunal, and then the Indian government lost the dispute and now also has to pay a certain amount of compensation to Vodafone. So arbitration is in spotlight in recent days, particularly due to these high profile and big cases, but it's much more than that. It's much more than that, and that we try to understand here. So the areas where arbitration can come into picture are very, very, very wide. So prominent issues which can come is that there can be arbitration between countries as well. So there can be two countries which can arbitrate regarding the borders of the countries, or the land borders, or either the maritime borders of the countries as well, or regarding access to resources. So should one country have access to water resources, or should one country have access to resources near the border? So these issues also come up in arbitration a lot. The second, and probably the glamorous bit of arbitration these days, is investor state arbitration. So this is what is the situation for Vodafone or Cairn India. So Vodafone and Cairn India are classic examples of investor state arbitration, which is now in spotlight because of two things. First, because of the very high value of awards which have been imposed by the arbitrator, and a very high value of compensation which has to be paid by the government. And the second factor here is that it has captured public's imagination that companies can now bring about disputes against governments, and then force the governments also to come to a discussion on settlement. So it has captured the imagination that arbitration is such a platform where two parties no matter whatever be the difference in power between the parties, they have to come to a common discussion forum and then try to come to a settlement. So investor state arbitration, where an investor who is not happy with the policies of the other government. So the investor basically comes from a country which is called the home state, and the other country where it invests is called the host state. So when the investor is not happy with the policies of the host state, then it can look into the agreements which the countries had signed. So between its home state and the host state, there's an agreement which is generally called an investment promotion agreement or an international investment agreement. And it can say that, yes, they said that in the investment promotion agreement that they will have investor friendly policies, but now they're violating it. And so we need to arbitrate against this or go for investor state arbitration. Third, and very common, very common, is commercial disputes. So commercial disputes come up all the time for arbitration, very favorable from that, particularly due to the fact that arbitration is generally faster and also is private. So a typical example of a commercial dispute which you can see in the newspapers always is between Amazon and Flipkart, and this is regarding Reliance Industries purchasing sorry, it's between Amazon and Kishore Biani, the Big Bazaar Group or the Future Group. So it's regarding Reliance Industries purchasing the shares in the Future Group. So that is, and then the Amazon moving to the Singapore International Arbitration Center in a dispute against Future Group that it violated its agreement with Amazon that it should not sell its shares to Reliance Industries Limited. So that is a typical example of a commercial dispute which has gone forward for arbitration. So it's very common for commercial disputes. It is private in nature, which keeps the dispute in closed rooms. So that is very favorable for the parties, and hence they generally go for arbitration for commercial disputes. Then we have family disputes. So family disputes are also a very popular platform. Arbitration is a very popular platform for family disputes, particularly because of the fact that, again, it's private in nature, so dirty linen does not get washed in public, and judges would rather like parties to come to a settlement than try to fight it out in the court, where things can get very emotional. Construction disputes, very common again. Arbitration clauses are generally present in all EPC contracts. They're always present generally. Why is arbitration very favorable for construction disputes? It's because you can appoint arbitrators who are technically qualified to deal with the dispute. So that's why they favor arbitration for construction disputes. They feel that if the construction dispute goes to a normal court, then the judges may not be well equipped to understand the nuances of construction in the court. So that's why it's very popular for construction disputes. For contractual disputes, again, it's very popular. If there's a party between two, there's a contract between two parties and there's a violation by one of them of the contract, then it's very popular that they try to resolve the dispute through arbitration. So this permeation of arbitration in contractual disputes is to such an extent that many Indian IT companies that I know of even include an arbitration clause in their employment contract. So the employees can only arbitrate against the employer, or the employer can only arbitrate against the employees. So this is very popular for employment contracts as well. Treaty-based disputes, this is between nations. When the two countries sign a treaty, they generally have an arbitration provision in it to resolve the disputes. And last, just an example, there are many more, just an example. So it's sports related disputes. So most of the anti-doping disputes go to the CAS, or Court of Arbitration for Sports. So arbitration is very popular for sports related disputes as well. So I think this is also in the spotlight. Whenever there is a doping issue which comes up, then the parties go to CAS, and then the CAS is then an arbitral tribunal which decides on the disputes. Now, just the final slide on the introductory topic of arbitration. So there can be many different types. Just to provide an idea, there can be ad hoc or institutional arbitration. So when we say ad hoc arbitration, what it means is that there are two parties who have come together without any institutional background, and they have just appointed an arbitrator or a arbitration tribunal consisting of 3 or 5 arbitrators, and they have told them to resolve the dispute. When we say it's an institutional arbitration, what we mean is that we go to a arbitration center or a arbitration court and then ask the arbitration court to conduct the dispute. So this basic examples is the New Delhi International Arbitration Center, or the Dubai International Arbitration Center, or the Singapore International Arbitration Center, or ICSID, where we tell them that we are coming to the institution, you conduct the entire proceedings, you appoint the arbitrators, or you help us in finding arbitrators, and you also take care of all the secretarial issues. Voluntary, compulsory, we already discussed before. Domestic arbitration and international arbitration. So whenever it's arbitration between two parties, generally it's domestic arbitration within the country, and international arbitration is when there is a foreign party also involved. And arbitration with a seat and without a seat, that is sometimes what is the importance of seat. So when we say seat of arbitration, it is the jurisdiction where the arbitration is taking place. So when we say with a seat, it means that in this place, the arbitration award can be challenged later in the courts, or the laws of these countries will be applicable to arbitration. Sometimes it can be without a seat also. For investor state disputes which goes to ICSID, then it's without a seat. Now, so now, coming to the point of the interaction between AI and arbitration, there is a famous saying by Professor Maxis Shearer. So she belongs to the Queen Mary University, and she has a saying which is almost always quoted, and she says that finding a lawyer who knows both artificial intelligence and arbitration is like finding a vegan butcher. So now I am also not the vegan butcher, so I also do not claim that I know a lot about artificial intelligence. I have certain knowledge about arbitration, but I'm not to the level that I can claim that I know a lot about artificial intelligence. So it's very rare to find someone who is competent both in arbitration and artificial intelligence. And why is arbitration frequently talked about in relation to artificial intelligence is because the primary factor is the flexibility in rules. And this means that you can experiment a lot in arbitration. Since the rules are flexible, you can experiment a lot in arbitration and bring about AI in multiple processes of arbitration, which you cannot normally do in a judicial process, because judicial process is governed by laws set by the government, and has to be uniform across the country. So it's very tough to bring about large changes in judicial processes, but you can do that in arbitration. You can do that because of the flexibility provided. And there is also a possibility that you can include things like AI, or experiment with AI in arbitration, because it deals with high stake matters. So the parties who are involved in arbitration, generally in high stake matters, they have greater access to resources, and they can spend more. So they can experiment with new things such as AI in case it improves their possibility of winning the dispute. So they will be more flexible in bringing it. Now, what we would now like to discuss, what we would like to now discuss is that we'd like to see the different steps of arbitration, and then see where can AI play a role in this different steps, where can AI play a role in these different steps, and what is being done currently in the world of arbitration. Now something which we must all understand here is that generally lawyers are not very favored towards big interventions. So they like things as they are going, and they feel comfortable in dealing with things as they are. So this is uh, this is something which they feel that this is their general bread and butter, and they should not disturb the entire process. So I'll just give you an anecdotal experience here. So there was a conference at an university in Frankfurt, so where we were sitting, and there was a discussion by a famous arbitrator, and she's also a partner at a famous law firm. And she said that there was an arbitration conducted through VC, or video conferencing. Now the people in the entire chamber, I was sitting there as well, they were amazed. Oh, some people agreed to conduct an arbitration through a video conference also. So this so for other people, for computer scientists or for people involved in other industries, a VC may be a day-to-day occurrence, or negotiations through video conference may be a day-to-day occurrence. But for these group of experienced lawyers sitting in a developed country, they were surprised that they agreed to conduct an arbitration through a video conference. So this is the dilemma here, because lawyers are generally not very flexible with adapting to new things which they feel might lead to any disadvantage in their entire dispute resolution process. So what they want to do is that they want to have a control over the process. They want to be able to understand whatever is happening, and they will only adopt something when they feel that they have complete control over the process, and them adopting this new technology will not give any advantage to the opposite party. And they're also careful in the fact that they do not want the opposite party to be able to use this new technology to put them at some sort of problem later. So lawyers are very careful in adopting to technology. But that does not mean that we have not seen an adoption of technology. Legal research is hugely dependent on technology. The fact that we now have case databases, we have award databases, it has completely changed legal research, and it has made it more user friendly and um, more, let's say, it has brought an equality into the field, because now a new lawyer coming into the profession, he also can have access to a lot of cases, and he can learn about new cases, or he can learn about old cases as well, or find landmark cases from the past, even without having an idea of what had happened at that time, or not going through huge piles of books, because he has access to digital legal research tools. So yes, there is a change, but the change is very, very slow, because lawyers are very, very careful about adopting technology. Now, moving ahead, going back to arbitration in particular here. So what are the different stages of arbitration that we need to understand before we can see the role for artificial intelligence in arbitration? So the absolute first stage is that the decision to go for arbitration. That's the absolute first stage. Now, why do I say decision to go for arbitration? So whenever there is a dispute and there is no prior arbitration agreement between the parties, then there's always a choice that should I ask the other party that we want to go for arbitration, or should I approach a court? Should I approach a court? So that's the absolute first step. So they then look into the different options available between them. So the disputing party looks into the different options available. So it will then analyze the data and see where can I have a greater chance of success. So is it arbitration, is it mediation, or is it the normal judicial process? Where can I have a better chance of success? So if there is an option, then they will go for arbitration only if they're assured that arbitration is the right way to adopt for this particular type of dispute. The second question at the time of taking this decision for arbitration is whether I want to go for ad hoc or institutional arbitration, ad hoc or institutional arbitration. Now, this decision is also very important, because what happens in case of ad hoc arbitration is that you have sometimes a flexibility of framing your rules, and but parties will then analyze, is going for an ad hoc arbitration advantageous for me, or if I go for an institutional arbitration, is the opposite party going to object to that? Now, why is this calculation important? It is a cost calculation also. Will ad hoc arbitration be cheaper, or will institutional arbitration be cheaper? Or it will be a calculation of a bargaining power also, that if I say ad hoc arbitration, then will I be at a situation that I am weaker than the opposite party, and I'll be at a disadvantage later in framing the rules of arbitration? So these are issues which the parties look at. Should I go for now ad hoc or institutional arbitration? So this is the first stage where AI can help, and I will talk about this later as well. So at this stage, in case there is an access to a mechanism where the AI can predict where there can be a better chance of success, whether it's judicial forums, or whether it's arbitration, whether it's mediation, or whether they should go for ad hoc or institutional arbitration. If there's a prediction possible, then AI will have a very big role here, and I will talk about that also later. The second is notice of arbitration. Now, this is a very very simple process actually. So here AI can be play a role in automation of the process. So in case the parties just input the data, then the AI system can probably frame the notice of arbitration and send the notice of arbitration to the other party. But now coming to the most important stage where arbitration and AI are already working together, and that is the selection of arbitrators. Now, I had talked before that selection of an arbitrator is generally done by the parties. So an arbitrator is a private person and the selection is done by the parties. And this is a point where the parties want to be absolutely sure that they're selecting the correct arbitrator. They're selecting the correct arbitrator, because if they choose an arbitrator who has a history of decisions which go against them, or who have a history of decisions which under which he has decided in a particular manner, then it can put them in a disadvantage. So selection of arbitrators is a step where AI is now playing a very important role. I'll talk about this. I'll talk about the systems in place, but here data is of utmost importance. So and prediction systems and recommendation systems here are very very important in selection of arbitrators, because you have to look through piles of data about how an arbitrator has decided in the past and how he is going to decide your particular dispute, and whether he has expertise on the topic or not. So selection of arbitrators is a point where AI plays a very important role. Next is determination of rules of procedure and seat. Now AI also plays an important role here, because what it has to be understood here is that the rules have to be generally framed by the parties in case of ad hoc arbitration. So if there is an AI system in place which can create the rules for arbitration, and also provide an overview of whether these rules would be conducive for the conduct of the arbitration, and predict that whether these rules will be sufficient, that would be very very good. Now I say seat. So this is also very important. Selection of seat in an arbitration is very very important. And why is selection of seat important? Selection of seat is important because after the award of the arbitration comes, the seat is where the award can be challenged. So you will go to the courts in the particular seat to challenge the award. So there are two perspectives here. So let's say there is an award which is seated in Paris, and after let's say there's an arbitration which is seated in Paris, and then the award is issued by the tribunal. Now when the award is issued, you can challenge this award at the courts in the seat. So you can challenge this award at courts in Paris only. Now selection of seat is very important, where AI can play an important role, because they can then tell the parties or recommend the disputing party that please select this particular seat only, please select it particular seat only. Uh, so the issue here is that in selection of a seat, what would the recommendation system look at? The recommendation system would look at past decisions of the courts in the particular country, whether it is arbitration friendly or not, whether in a particular area whether the courts have decided in a particular manner or not, or in this particular subject area whether courts have favored arbitration or not. So arbitral systems can recommend the seat to be AI systems can recommend the seat to be chosen for arbitration. The next process is document discovery. Now document discovery is something which lawyers in India are not very aware of, or also lawyers in civil law countries are not very aware of. So what is this document discovery process? So this is particularly something which is done in the US. So what they do is that they can request the arbitrator, or they can request the court and tell the court or the arbitrator that the opposite party has a pile of documents which contains important information, and these documents should be accessible to me so that I can bring this information for the before the arbitral tribunal or before the court. So what they say is that we want to be able to scan all these documents and then find the relevant information and then bring it before the tribunal or the court. So the court or the tribunal will say that, okay, please scan the documents which the opposite party has and then bring the relevant information for us. Now, as you must have seen, this document discovery process can be very cumbersome. So what do parties do is that parties bring out lakhs of copies of pages and then tell them, please find the information that you want. Now this is very cumbersome for human work, because lawyers can be involved for thousands of hours to find the relevant document, and AI can play an important role here, and it is already being used to find the relevant documents for the case. Just to show you how cumbersome it is, as late as 2015 they were still doing the document discovery work for cases which related to the 2008 financial crisis. So you can see that how many documents parties try to give each other to confuse the other party, to basically hide the information in the documents. So you imagine 7 years have taken for the document discovery process, and they were still going on in 2015, they were still going on in 2016. So why automation is required here, and why AI can help us find the right documents during the document discovery process. um, Other things, examination of witnesses, presentation of evidence, these are also places where AI can play a role. The next important point which I would like to talk here is uh, decision for challenge and enforcement. Now this is a very important point here, because what happens is that in case an award does not come in your favor, you'd want to challenge the award before the courts. Now challenging an arbitral award in a foreign country can be very expensive. So you need to know whether you should challenge it or not, or is the challenge going to be more expensive than the payment from you itself. So an AI system can help you predict whether this award is worth challenging or not. And lastly, decision on enforcement. So the winning party would like to know where it should enforce the award. So what is enforcement basically? Enforcement basically is asking a court that this party which lost the case has some assets in this country, and I want to take the money by selling these assets. Let me give you an example. So let's say that Cairn India has won the arbitration award and would now like to take the money from the Indian government. So Indian government will not give the money so easily. So what does Cairn India have to do? Cairn India has to find places where India has assets. So what are India's assets? India's assets can be money in the Indian public sector banks, or Air India's planes, or India's ships in harbors abroad, in basically ports abroad. So these are India's assets. So what will Crane India do? Crane India will try to go to every country and try to tell a local court that, please hand over India's assets to me. They have lost this arbitration case, and please hand over these assets which belong to India to me. And they have already done that. They have approached the court in New York and they're saying that, please give me Air India's planes, because India is not paying the money that they should pay me. So this is the enforcement process. Now, where does AI play a role here? AI can play a role here in identifying the assets which belong to a particular person. So there can be a web of companies, there can be a web of assets. So AI can help you identify which assets this award should be enforced again, or which country they should try for enforcement, because selecting the correct country is important. There may be countries where enforcement may be impossible. Let's say the Cairn India decides to enforce India's awards in Indian courts itself, then it is very likely that it will not get a favorable decision. So they have to understand what should be the correct forum where they should enforce the award. So this is also very important. So moving ahead, let's try to now understand what is happening actually. So we know that there are all these steps where artificial intelligence systems can play a role. So what is actually happening at the moment in the current scenario? So to begin with, these are the different places where AI comes into picture. So I've already talked about just two or three things that I may have missed out here. Drafting of documents with templates, AI can help. Proofreading, AI can help. Finding case laws and reference for analysis, definitely AI can help here. Translation and transcription of documents, Of course, there are already systems in place. Cost estimations, scanning of documents for arguments, definitely. Also in the discovery process, document discovery process, AI can help. uh, Determining the quantum of damages, so based on the case, AI can help you predict what is the award that you can win, how much damages can you claim. So those are the systems where AI systems can come into place. Now let's see what is already happening at the moment in the market, what is already going on. So where is AI being used in the pre-arbitration procedures? So where it is already being used. The first point where it is being used is in the framing of the arbitration clauses. So I had told you the arbitration agreement between the parties. So the arbitration agreement is generally a 3-line clause in the agreement which says that the parties agree to arbitrate this dispute. Parties agree to arbitrate this dispute. But there's a lot of litigation on this clause itself, that sometimes they say that no, we did not agree. The other party basically did not mean that they will mandatorily go for arbitration. They say that it's an option for arbitration only. Or they say that no, we did not choose the particular seat by this clause, we chose another seat, and the other party is misinterpreting the selection of the seat. So these are issues where the parties always fight about. So framing the correct arbitration clause is important. So the American Arbitration Association, what they came up with is that they came up with a tool called the clause builder tool. So this clause builder tool helps the parties frame the correct clause for the arbitration agreement. Call it clause for the arbitration agreement. The second is the step that I had talked about regarding selection of an arbitrator, seat, rules, and forum. So for this thing as well, there are already mechanisms in place, or people are working on it. Like Jusmundi, an organization based out of Paris, they are compiling data about arbitrators from across the world, and they help you identify the correct arbitrator for your particular dispute based on the seat, based on the forum, and based on the institution. So they will recommend you that this is the person, and you can look through the profiles of the arbitrators also and select the correct arbitrator for your dispute. Similar work is also being done by Arbitrator Intelligence, another platform based in the US. They're also working on it. And for mediators, there is also something called Billybot, which is based in the UK. So this work is already being done in selecting the correct arbitrator. There are different companies working on a commercial basis to help you find the correct arbitrator, help you find the correct seat, rules, and forum for arbitration. In India, just to mention one organization, there is also similar work being done for tax decisions by an organization called Riveras, also on a commercial basis. So they are trying to predict who is the appropriate judge or who is the appropriate forum for you for the particular dispute, for the tax dispute. Uh, then there is a role for AI systems in determination of probability of success. Now, this determination of probability of success directly is something which is very controversial. That can an AI system, without knowing the actual situation on ground, predict the probability of success? But what they're trying to do is that they're trying to come up with approximate numbers. So there is something called an arbitration engine. It's a project which they are working on, that they are saying that we can at least try to predict the potential outcomes. We are not saying that this will be the success rate, but we are trying to predict what could be the potential outcomes that a particular arbitration will lead to. So there's already a platform which is working on it, which is called Arbitration Engine. Then there's a need for systems which determine the arbitration strategy in terms of costs and time for dispute resolution. I do not personally know of any particular systems which are already in place there. There's another system called RBLEX, which can be used to understand desirable outcomes. And it also helps the parties in decision making as to what should be the approach that they should take in a particular dispute. Lastly, in the pre-arbitration procedure, you always have to schedule these meetings with arbitrators and the different parties and the lawyers of the different parties which are involved. So there are different schedules in place. So there's a system called X.ai, which helps you in scheduling the meetings and hearings. So they will automatically predict the different slots for the persons where a person is likely to be free, and then you can, or ask the system to send out reminders or alternative slots so that a common slot for arbitration for all the parties can be fixed together. Now we already also have systems which are working during the arbitration process and helping during the arbitration process. So we have something called Kira, which is used by big law firms to extract information from long and complex documents. We already have law firms in India which are using Kira, and they try to extract the important relevant parts from the long complex documents. We have a system called Disco, which is used in the e-discovery process. So I talked about how document discovery can be very, very, very challenging, and it might involve thousands of pages of documents. So Disco basically helps you to identify the correct documents based on this entire pile of documents, and then helps you to collect the information from these documents and build your case as well. So Disco is already being used by law firms. IBM, the IT major, had also used its system called ROS to handle bankruptcy cases or identify key bankruptcy cases. And the IBM AI system called Watson has been used to review important cases and articles and select or extract relevant information from this. Now, as you must already know, and you must have heard about it in the past cases are very important in arbitration. So while they are not binding on the new tribunal which is deciding your dispute, they can help to convince the tribunal. So AI based case research is very, very popular, very, very popular. So we have platforms such as CaseMine for US cases, LegitQuest for Indian cases, and Westlaw, which is one of the biggest commercial manufacturers. They have something called Westlaw Edge, where they're using AI to get select cases which might be relevant for you. And now JuiceMundi, which I talked about, they also have a special system for searching arbitration awards. So arbitration awards are also being largely compiled. Now what I believe is that there is also a potential for AI to work in predicting strategies by the opposite parties. Now this is very, very important, because if you have a system which can predict what could be the potential defenses to your arguments on what is the appropriate strategy which can be used to take the case ahead, that can also be very helpful for lawyers working in arbitrations. And this is, I think, something which can be further worked on. Now the next issue here is regarding the process of actual decision making and predicting the decisions. Now this is probably considered as the final frontier in the entire process, that is AI system itself acting as the arbitrator. Now there's certain hurdles to this. The problem here is that laws in certain countries may not allow machines to make decisions as arbitrators. So I've just given a law on the OHADA countries. So there are a group of 17 countries in Africa called OHADA countries, where they have it inscribed in the law itself that only a natural person may be an arbitrator, and he needs to have full capacity to exercise his civil rights. So this is very, very important, that law may not allow you to have an artificial arbitrator as yet, or a machine deciding as yet. But what we can have is we can have recommendation systems which can help the person to come to a decision, or the arbitrator to come to a decision. And we already have that in use in different courts. So mixed human and AI based processes are possible. Arbitration systems, the main problem regarding the key hurdles in having an artificial arbitrator here, yes, definitely, Mr. Go. I'll wrap up in 5 minutes. The main hurdles in the process are four types that was identified in Professor Scherer in her landmark papers. She said why we cannot have an artificial arbitrator as yet, and artificial intelligence arbitrators and yet. So she talks about four V's, and I seem to agree with the four V's that she says. The first thing that she talks about is volume. She says that we do not have the necessary volume of our arbitration awards in place, that we can have a system which will be able to take the correct decision every time, or which can always predict the correct decision every time. Second thing she talks about is variety. So since there are a lot of different issues where arbitration can be used, or different subject areas, so we may not have the appropriate variety of awards to come to a correct decision all the time. The third point is velocity. So the number of arbitration awards which are issued all the time is tremendous. So there are arbitration awards issued all the time, and new law is developing all the time. So can the AI system adjust to that, is something which is not yet known. Last is veracity. So this is regarding the black box in AI systems, that we sometimes do not know how the machine is deciding, how the machine is deciding. So this is a point that in law there is a thing that justice must not only be done, but also must also be seen to be done. So you need to know that justice is being done. There's a transparent process for the decision making which is happening. So this is something which is yet to come into play. Now we have other problems, such as an issue of legal backing for AI based decisions, as to will take the responsibility for AI based decisions, or there is a lack of accountability for decision. And the fact that certain things such as public policy, which is very important in arbitration, these are very abstract concepts. We do not know if a machine can identify them or understand them clearly, and these are also concepts which are continuously developing all the time. So just to summarize what are the hurdles that we have, is that we have a fear of a technology divide. So we may have a situation where the big law firms may be able to have access to AI based systems, while the smaller lawyers or the smaller firms may not have access to AI based system. So there's a fear of a technology divide. There's a lack of awards which can be used to build good prediction systems. There's a need to change the domestic laws and international conventions also to promote AI and arbitration. Technology and transparency balance, we do not know that as yet. AI systems need to have an understanding of different domains, and there's need to develop a system where humans can step in if the other party finds out a way to game the system. So this is a very big fear, that the other party will game the system, and then the machine will always decide in a particular manner. So there's a need for human intervention all the time. But what I definitely see is a role for AI as a supportive system in arbitration. In all the steps, pre-arbitration and during the arbitration, I see a role for AI in assisting the lawyers, finding the right case laws, finding the right forum for enforcement, selection of the arbitrator, selection of the case laws. This is something where definitely AI will play a role. More fields which can be worked on in the future are AI based mechanisms for small disputes. So these are already in play, where a AI mechanism already decides small disputes, particularly small disputes, let's say value less than $1,000. They can be decided by AI systems to begin with. We need to frame clear rules for confidentiality and privacy for AI, and also rules which would specify what would be the role for AI in the future in arbitration. So these rules are absent at the moment. Lastly, we need to build all those vegan butchers, and come up with rules like Asimov's rules of robotics. So we have those Asimov's rules of robotics, which says that a robot cannot do certain things. So a robot may not injure a human being. A robot must obey orders given by human beings, and a robot must protect its own existence. So we need things like Asimov laws for robotics, for AI in law as well. And then I believe that AI can work together with law, and also have an important role in arbitration. Maybe not as a decision maker in the immediate future, but definitely as an assistance forum for decisions in arbitration, and across has a role across the different steps of arbitration as well. Now, yes, that's about it from my end. Thanks to all the organizers of SAIL and all the attendees who have been very patient to listen to this discussion and to this lecture. And let's see what we have ahead in the future for AI and arbitration. So thank you. Back to you, Dr. Ghosh. Yes.
So, thank you for the wonderful talk. It was just absolutely, heartening to know that the handshaking and the confluence is really happening uh, between AI and law. So, thank you very much. for this enlightening talk. And I think we can now take some questions, as I see that many questions are coming. We can take them one by one.
Absolutely, absolutely,
So the
definitely.
first question is by Vishal. Uh, the question is, sir, can you please put more light upon without seat arbitration?
Yes, I'll just put it in short in a minute. So what happens is that in disputes, particularly in investor-state arbitration disputes, which happen in ICSID. So ICSID is a World Bank division based in the United States in Washington. So if you have a case in ICSID, it's considered to be a dispute without a seat. So you cannot challenge an ICSID award in the local court in Washington. So you cannot also challenge an ICSID award at the enforcement stage. So an award by ICSID stands on its own all the time. So since there is no seat in the award, basically it cannot be challenged. So that's why ICSID is a forum where there is no seat linked to it. And the dispute is considered to be without seat for this is to provide an assurance to the parties that domestic courts will not interfere in arbitration. Absolutely.
Okay.
Yeah.
So maybe you can take the next question.
Yes.
It's by Zacharias. I apologize if I mean that is not the correct pronunciation.
Yeah.
So the question I think is in okay in RE AI for appointment of arbitrator
Yep.
uh, in reference with I think.
Yes.
Uh, how does AI determine the competence of an arbitrator without any data on precision passed by the arbitral tribunal?
Right. So, what Jusmundi and Arbitrator Intelligence are trying to do is that they're trying to build a database of cases. They're trying to build a database of cases. There is a factor here that they source the cases from two forums. Firstly, they source it directly from the institutions which conduct the arbitration, and they also source it from the parties themselves. So yes, they're trying to do it. And they are getting better over time. Of course, certain domestic awards may be missing, but high value awards, particularly international commercial arbitration awards, are always there, generally in Jusmundi and Arbitrator Intelligence. So they're trying to come up with it. Maybe in the future we'll have more domestic parties also disclosing the decision so that they can be compiled. Now what parties are doing is that parties are now giving anonymous awards. So they hide the names of the parties and then give the award for compilation. So this is also increasingly happening now. Right.
Okay, thank you. So the third question is by Kavita Sharma.
Yeah.
The question is, what is your views, or maybe what are your views on the implementation of AI in healthcare sector?
Yeah.
We have successful cases of use of AI in hospitals and labs. More importantly, post-COVID. That's a good question. Um,
Absolutely. I am very much in favor of AI in the healthcare sector, and I believe there can be a lot of use cases, particularly in suggesting appropriate specialists for particular disease, or finding old case histories to find what treatment protocol was followed in a particular case, and then implementing it in a new case. The concern I have here, only concern which I have here, is regarding privacy of personal information which is compiled in health systems, and whether we are able to build a system which complies both with privacy laws and also is helpful for the public, and how we can anonymize the health data. So that would be very important, and if that problem can be solved, then I think AI has a major role in health systems as well.
yes.
Yes.
Thank you. So I did not mean that the other questions are bad. So this just
Yeah.
basically came to me. That's why I
Yes.
said that that's
Yeah.
basically a good question.
Yes.
So the next question is by Meera Patel. The question is, assuming that Indian laws permit or start permitting use of AI to select arbitrators, browse their histories, so is it
Precedents, etc.
precedents,
Yeah.
etc. Would it not amount to forum hunting? What safeguards can be put in place to avoid selection of arbitrators with such bias and prejudices?
Uh, uh, Ms. Patel, I would just go one step ahead, and I would say that law firms already do it. Law firms already do it. Particularly, we do not know when they do it, but there are people who are already involved in this. They have a team of people who are involved in research, identifying the correct arbitrator, and selecting the correct arbitrator is a month-long process. So they would go through different profiles, they would go through case histories, and they first shortlist a name of like 10-15 arbitrators, then they go through the history of cases. So this is already almost already done. There's nothing which prevents this from being done. At least you cannot prevent it. So what they do is that if a particular domestic law prohibits it, they just say access that arbitrator information from France and just select the arbitrator and send the name here. It's not that anything we can do to prevent it. What is the problem is a forum hunting. Well, it's not particularly forum hunting, because you have two teams who both try to select if arbitrator favorable to them, and then the third person, the presiding arbitrator, is generally chosen by these two arbitrators. So the presiding arbitrator is generally the person who is supposed to be the balance, the person who brings in the balance, and who is supposed to be someone who is not directly representative of the parties. So arbitrators by themselves are supposed to be neutral, but the presiding arbitrator is supposed to be the absolute controlling balance in the entire scenario. Yeah.
Mm. Okay. Okay. So I have one last question by Zacharias again. How does
Yeah.
a lawyer improve his technical understanding of AI? Any suggestions for courses?
Uh, well, my understanding of AI comes because of my flatmates in my university in Germany. I was very privileged to have three computer science graduates with me studying there. So I learned the basics from them, and I do not consider that I know a lot about it. What I can say is that there are good courses in online platforms, free courses on AI as well. And these are basic courses which are not targeted, let's say, at computer scientists. So we can learn about the basics of AI from there, and then start off. I would say that if you particularly read papers by Max Scherer, you could know about the latest developments in the field. So Professor Scherer is particularly the person I think who is leading the revolution, and I think you can look at her papers. She covers it from basics to advanced discussions as well. So that's very, very important. Yeah, that's it.
Okay, so thank you very much for answering the questions, and thanks again for the
Yes.
intriguing talk, for the
Yeah.
exciting talk. And
Yeah.
we have exceeded the scheduled time, I mean, basically the duration which we had in mind. So I would like to thank the speaker again. And I would like to thank the wonderful audience who have been asking such wonderful and insightful questions. So I will say a goodbye to you. Thank you very much. Please, I mean, stay with us. We have some more exciting talks. I mean, one more exciting talk and a wonderful panel discussion coming up. Please be with us. So I will now close the session, and I would request Angshuman to join the other link for the private discussion. Thank you very much, everyone.
Thank
Thank
you,
you.
everyone. Thank you.